All right, so let's get started today. This is a Tag Inspector webinar. We'll be discussing tag governance, optimizing data collection in today's privacy environment. Just a quick note before we dive in, a couple just notes for upcoming webinars and events. Next week, for those of you that are familiar with the Tag Inspector, tag auditing monitoring platform, there will be a pretty major release with a whole new styling and look and feel of the user interface, along with some additional functionality around conditions reporting, as well as user management. So we'll be having a webinar on Tuesday, 10 a.m. Eastern time. I know with many people in Europe, that'll be in the afternoon, so around 4 p.m. European Standard Summer time. But yeah, we'll be going through the new UI as well as that new functionality. So please hop on the website, register for that if interested. And then also for anyone that is in the States, Tag Inspector is a product of InfoTrust on the InfoTrust side of the house. We're doing analytics roadshow events coming to potentially a city near you. So feel free to pop in and join us for any of those. So to get into it, just a little bit about Tag Inspector and myself. I'm Lucas. I'm our product manager for Tag Inspector and also work with a number of global organizations on tag management, tag governance, and how to do exactly what we're going to be talking about today, optimize data collection with respect to different privacy regulations and things that you need to keep in mind, as well as just how to optimize the architecture for optimal data collection, performance, and all that. A little bit about Tag Inspector. It is a tag auditing monitoring platform. It's a product of InfoTrust. On the InfoTrust side of the house, we do tag management as well as digital analytics consulting work. So work with a number of global organizations on that data collection architecture, tag management, really the whole nine. Work with thousands of websites, do a number of different training modules, including webinars like this one that we're going through today. Quick disclaimer, we're going to be talking quite a bit about some of those different privacy laws and regulations, including GDPR, EPrivacy Directives, and then as well as the new California Privacy Protection Act, which for anyone doing business in the United States is going to be extremely relevant to you very, very soon. But I'm not an attorney. This isn't legal counsel. We'll be going through some best practices and some interpretations of those different regulations. But at the end of the day, you need to consult with your own legal counsel to define your policies and processes as it relates to these different things. So with that out of the way, want to first just touch on the different acts and initiatives. We're going to spend the first half, maybe a little bit more than half of time here going through reviewing these different laws, regulations, so we get a really good base understanding of what is the current privacy environment, what are the requirements when it comes to tag management and tag governance, and what are the things we need to keep in mind. The four main things that we're going to really focus on. The first is the General Data Protection Regulation, GDPR, which everyone on this webinar should be very, very familiar with, in that it went into effect last year. I'm sure most organizations went through quite a bit of effort in order to be able to prep for that. And I know some of that prep is unfortunately still ongoing, but we'll review the requirements there just so that we continue to understand and keep in mind everything that's required there. We'll then discuss some of the different EPrivacy directives, or those cookie laws that are in effect in the EU. Those are country specific at this point, still working on kind of codifying everything and applying it across the entire area. But we'll go through just a few examples of those and what that means for compliant data collection. And then finally, we'll go through that new California Consumer Privacy Act and the requirements as it relates to California residents. And really it applies and will soon apply because many additional states within the United States are also looking at passing similar acts. And the federal government in the United States is working on drafting legislation to try to standardize those types of rules across all of the different states within the US. So we'll go through that and kind of throw some additional requirements on the pile as it relates to data collection. Finally, we will touch a little bit on some of the different technology initiatives. There are some, obviously, hardware initiatives and companies putting out some different technology in response to consumers and users' privacy concerns. So we'll touch a little bit on the Apple's ITP initiative and what that means for you in relation to data collection. Perfect. So that's what we'll be focusing on in terms of the agenda and how this flow is going to work. We'll start out focusing on GDPR. We'll touch on those EPrivacy directives, go through that California Consumer Privacy Act. We'll then get into what these different requirements and what these things mean for your business, what you need to do, some actionable next steps in order to be able to get your tag governance policies, processes in the state really that they need to be in order to optimize compliant data collection. We'll then talk about optimizing compliant data collection, some different things that you need to think about. We'll touch on those ITP considerations, and at the end, we'll do a quick summary Q&A. One note, if you have any questions as we're going through this, I always like this to be a little bit more of a conversation as opposed to just one way. So if you have questions that come up, please feel free to drop them at the point in which they come up in the questions pane there in the GoToWebinar control panel that you should have. And I will try to get to those at the point that they're raised. Anything left over, we'll just cover at the end. So to start with GDPR, a quick overview and some, quick overview and some important definitions. So thing to keep in mind here, intent of the regulation, just to instill basic privacy rights as human rights for citizens within the European Union. Punishments, really big, and this is what got a lot of publicity, up to 10 million euros or 2% of annual global turnover, whichever is higher when it pertains to just violations or improper collection of personal data, and then up to 20 million euros or 4% of annual global turnover for egregious violations, or once an issue is raised, not doing anything to address it. It also gives the right for compensation claims for damages or suffered by individuals. So there can be private action taken against organizations and the resulting reputation damage and loss of consumer trust that comes with, publicized violations of GDPR and privacy concerns. It's one thing that's always important to remember, and I always discuss this with all clients that we work with. You're not the only ones that are affected by this regulation. Everybody is. So it really is a competitive advantage if you can get to the point where you are optimally collecting data in a compliant and private manner. A few important definitions that are going to continue to come up as we're going through this, and it's also super important to understand specifically what personal data is as we go through like auditing and understanding what are the different pieces of collection that this is really going to apply to. So the first is controller. That's the person determining the purpose and means of processing any personal data. So that would be the in business. So if it's you that has the websites that's on which you have different tracking technologies and advertising technologies, collecting information about the user, you'd be the controller. The processor in that scenario is going to be the person or the organization responsible for processing that personal data. So if you're using an advertising platform, or even if you're a media agency that is doing work on the data that's collected, creating audiences, targeting, that sort of a thing, you would fall under that processor definition. Personal data under GDPR, it is a pretty wide general definition. Any information that can be used to directly or indirectly identify the identity of a natural person. That includes pseudonymized, I always struggle with that word, data that can fall under that scope. So even if you have a quote unquote anonymous unique identifier for an individual, such as maybe you're hashing an email address, sending that up to your DMP, or with analytics, you're going to have just an anonymous unique identifier that's collected for an individual. That can still fall under this definition of personal data. depending upon what you're doing with it. So if it's easy to roll back, I know in some cases, some like DMPs or customer data platforms, they're hashing an email and then they're combining that with other data sets with the same unique identifier that they're pulling down from cookies that might be being matched across different websites. In that scenario, because you're developing basically a quote unquote anonymous profile of an individual, you're getting to the point where you can indirectly identify that individual. So that would fall under that personal data type of classification. Finally, processing any operation that's performed on personal data or on sets of personal data. This includes things as simple as like downloading or exporting or manipulating data within a spreadsheet. All those things are considered processing. When it comes to GDPR, there's 6 primary principles, and if we can remember these and keep these in mind and just consider these when we're looking at the data collection or the different platforms that are going to be in use, that's really the key here. So the 6 principles are: personal data shall be processed lawfully, fairly, and in a transparent manner. Basically, you have to have a lawful and actual business true reason for collecting the data. You can't just indiscriminately collect personal data about individuals, as well as individuals need to be aware of what personal data is being collected, how it's being used, who it's being shared with, all of that. The second principle, data must be collected for a specified, explicit, and legitimate purpose, and it cannot be further processed in a manner that is incompatible with those purposes. Again, you need to have a legitimate reason stated and transparent in order to be able to collect personal data. Number 3, personal data shall be adequate, relevant, and limited to what is necessary. You need to be collecting the bare minimum of personal data in order to be able to accomplish the business goal or the business purpose that you're setting out. Personal data, number 4, shall be accurate and where necessary kept up to date. Every reasonable step must be taken. Any personal data that you're collecting about an individual or profiles, things like that that you're building, that personal data needs to be accurate, updated as things are updated, and if there are any errors, it must be corrected or deleted. Number 5, personal data shall be kept in a form which permits identification for no longer than is necessary for the purpose in which personal data are processed. This basically is just saying that you cannot indefinitely hold on to that information. So one big thing, an implication in the marketing advertising space, in most analytics platforms, you are just indefinitely holding information. That is no longer the case, at least to be compliant with GDPR. So you probably would have seen, like if you're using Google Analytics, for example, they introduced around May of last year when this was going into effect, the ability where any data that's associated with an individual, so anything that's associated with like a user ID, is going to can be automatically deleted after a particular number of months. The default now, I believe, when you're creating a property is after 36 or 38 months. Any data associated with an individual user is going to be deleted. So same concept for anything else or any other platforms through which or with which you're collecting personal data. Number 6, final principle of GDPR, personal data shall be processed in a manner that ensures appropriate security of the personal data. Basically, you just need technical policies and processes in place in order to be able to ensure that personal data is safe. One key here for those 6 different principles and the rights that are afforded to the individuals, it's the controller that is ultimately responsible for and must be able to demonstrate compliance with these principles. So even if you are sharing your data with a processor and they're the ones that violate these principles in some way, at the end of the day, you, the processor, the one that is responsible for the definition of and collection of that information, is ultimately responsible. So you need to hold any partners or vendors that you're working with to account for these different items. That first principle, where we need to, all personal data must be collected and, lawful and for a particular business purpose. That lawful basis for processing is one of the first things you're going to want to go through, and we'll go through those different audit steps here a little bit later. But when we're thinking about, a new platform that we're adding to a website, or when we're thinking about creating our tag governance policy or auditing for purposes of tag governance, we're looking at the different platforms that are loading, and then we're looking at what data is collected. And if anything is collected that would be classified as personal data, we must have a lawful basis for processing or collecting that information. So the rules here under GDPR that we need to keep in mind for that collection is that our lawful basis for processing must be determined before the processing occurs. We can't just collect stuff and then after the fact say, oh yeah, we actually use it for this. You must define that, outline it, document it prior to that processing occurring. All processing must be necessary. Your privacy notice must specify the lawful basis that you're using for processing. And under the regulation, there are 6 lawful bases of processing that are available to you. For those 6, you can see them listed there. For purposes of marketing and advertising data, we're really going to just be working with either consent or legitimate interests. And I'm sure your organization's probably gone through this type of exercise, and many organizations here in the EU are starting to rely on consent for that collection and that processing of data. But to get into these a little bit more, for those 2 different lawful bases that you would be using for marketing and advertising, the first one being consent. Consent is harder to obtain, but it's much easier to defend. You can show, and you should have records. It is required that you have records of consent from individuals, who's consenting and to what. So what does consent mean under GDPR if we are using this lawful basis for processing? You can see the actual wording there: any freely given, specific, informed, and unambiguous indication of the data subject's wishes. Basically, it's just clarifying that the indication must be unambiguous and the user must be providing a clear and affirmative action. This is explicit consent. We cannot imply consent based upon a user interacting with our website or clicking through to another page or scrolling on a page, for example. They must be explicitly consenting to the collection of the personal data, and it must be transparent to them who's collecting it, for what purpose, where it's being shared. In addition to consent, you could also be using legitimate interest for your legal basis of processing. Legitimate interest, it's much easier to obtain. We can kind of just justify it on our end and then collect that information, but it is much more difficult to prove and requires a lot of thought as well as documentation in working through that process to be able to make sure that this is lawful when we're using legitimate interest for that collection. It is explicitly stated within GDPR Recital 47, the processing of personal data for direct marketing purposes may be regarded as and carried out for a legitimate interest. It's a little ambiguous, but it does leave that option open. If we are using legitimate interests, there are some things that you really need to keep in mind. So you must be able to show that the use of personal data is proportionate, has minimal privacy impact, and that people would not be surprised or likely to object if they fully knew the extent of what data was collected, how it was used, what the result was, and what the result was for them. So you also want to just keep in mind, and we'll touch on this more here momentarily, that the collection of that and the processing of that personal data is still compliant with our EPrivacy directives. Again, we'll get into that much in more depth soon. And then from a documentation and just a process perspective, when we're going through legitimate interest or using legitimate interest as our lawful basis for processing, we need to go through 3 different steps, and all these need to be documented and outlined. First one is going to be our purpose test. So we need to define what is the purpose for the collection of this personal data. What is our legitimate business interest for which we are doing this processing? Second one is going to be the necessity test. you need to be able to prove that it is absolutely necessary to collect that particular data for, that personal data that's being collected in order to be able to achieve your stated purpose. The third element is our balance test. So we need to be able to balance the interests of the subject with their rights, freedoms, all that is afforded to them under the law, and balance that with the business benefit that we are seeing as a result of the collection of that that personal data. So that balance test, basically we just need to show that the risk risk of harm to that individual is low, while the business value for us collecting it is high, especially as it relates to value that the consumer or that individual is going to see as a result of us doing whatever that business process is that we're doing with that personal information. We must include all the details of our different tests, legitimate interest, our assessments, what's being collected, where, how, who shared with, result to the individual. All that needs to be included within our privacy notification. And then in the context of marketing, the right to object is absolute. So even if we are using legitimate interest here, the individual still has a right to opt out or say, no, you cannot, I do not want you processing my personal information. As soon as they say that, that right is absolute. We can't say, well, we have a business case. No, got to stop at that point. In addition to what we went through for those 6 different principles and this lawful basis for processing, there are also 8 different rights of individuals that we need to keep in mind. And this really more so relates to like our privacy notice and the different disclosure methodologies that we might be using. So the first one is the right to be informed. Again, needs to be transparent what personal data is collected, by what platforms, how it's used, what the result is for the individual, what our lawful basis for processing is, all of that. Users have a right of access to their personal data, so they can request for you to provide to them what personal data was collected, the specific data points, all of that. They have a right to rectification. This relates to that principle where if anything is incorrect, you must get it fixed in a timely manner. Right to erasure. Any personal data that you've collected about an individual, upon request, you must delete it. That extends also to any third parties with whom you have shared that personal data as well, or have processed that on your behalf. Right to restrict processing. It's the right to opt out, say, nope, don't want my personal data being processed. Right to data portability. So again, a request for their data, you must provide it to them in an easily portable format so that they could use that or transfer it to a different platform or a different organization. They have a right to object, again, right to opt out, and then rights in relation to automated decision-making and profiling. We can't profile individuals or automate machine learning algorithms based upon profiles that harm the individual. So things like identifying certain characteristics of an individual and then offering them higher pricing for tickets or any type of a good or a service. Those things are not allowed. Last thing we'll touch on here as it relates to GDPR is just accountability and governance. You're required that you demonstrate compliance with the 6 different principles, and then it also explicitly states that it is your responsibility. Again, as the controller, all of these things are your responsibility, from the disclosure, transparency, all the way through to the actual collection, making sure that's a lawful basis, as well as the processing that even partners might be doing on your behalf. There's also organizational measures that you must have in place. You need privacy by design, you need data protection by default. Some of these things that are required from a documentation standpoint: privacy notice, records of consent, controller processor contracts, like data sharing agreements must be in place. Data protection impact assessment reports. Those would be those different tests that you're doing both on just organizational processes and protections for personal data, as well as records of data breaches. You need to be able to maintain those and provide those upon request. It's going to be a requirement to map your data flow or walk the data through the entire process. We'll get to that a little bit more here when we touch on the practical implications for your business. And then finally, you need to have technical measures in place to ensure the protection of personal data collected and processed by individuals. There's some examples there: pseudonymization, transparency, monitoring of processing, all that. So that's GDPR. I know most people are familiar with that, but always good to have a little bit of a refresher. Now we'll quickly touch on the EPrivacy directives that are out there. So the EPrivacy directives are those cookie laws that are out there in Europe. So they were outlined in EPrivacy Directive, which is EU-wide, which basically was just saying that as technologies have the ability to store information about users, it becomes important that those are, or that activity is regulated. But the directive does leave it up to the individual member states to define their own guidelines and requirements. And that's still the case currently. So cookie laws are going to vary a little bit from country to country. So you need to be able to understand for the different web properties that you have, where are those users accessing those sites from, to what markets do they serve, and then on a market by market basis, you would need to make the determination of what constitutes consent for the placement of cookies. What is the requirement of consent for the placement of cookies, as well as the disclosure. So I've listed out here 5 different examples that we'll just quickly touch on, just so you can see the breadth and the variability, I guess, from one country to another. So within the UK, consent must be freely given, specific, and informed. It must be an unambiguous positive action, but it is explicitly stated that it does not necessarily have to be explicit consent. As long as it is an affirmative positive action that the user is made aware of, that when they take that action, that is going to result in placement of cookies. This can be interpreted a little bit different in some different ways by different organizations and their legal teams. I've worked with some people that just accessing the website is considered a positive affirmative action, but it is transparent that by accessing this website, we are placing cookies. In other cases, it might be on a scroll action or just clicking through and going deeper into a website. In Germany, consent is only necessary for non-pseudonymized personal data. So if it's like clear text email, something like that being collected in a form, at that point, that consent would be necessary. But if it is a pseudonymized data point, such as a client ID or a unique anonymized identifier, you can collect that without consent, but the user must be notified of that collection happening, oftentimes with a banner, as well as they must have the ability to opt out of that collection. Spain, consent to cookies can be implied when a user has been informed about the use of cookies, and then the ability to delete them. So again, just notification, oftentimes with the banner, and then they also must have the ability to opt out of that placement of cookies. Sweden, much more relaxed. Consent can be communicated through browser settings, but information does need to exist so that users can be aware that cookies are being used. So again, notification requirement. Finally, France, which is probably one of the more strict ones, free, specific, informed consent must be given to set cookies. Positive indication with the ability to not grant consent, as well as the ability to opt out. So this is like explicit consent that must be given in France. There is, however, an exception for any data that is collected in an aggregate and fully anonymous manner and used in such a manner. So like your web analytics, standard web analytics tracking would be allowed outside of that explicit consent. So that is ePrivacy. It's important that we touch on those different cookie laws, because when we talk about data collection on your websites, that's happening via those JavaScript tags that are executing. When those tags execute, they're going to be setting cookies. So the placement of cookies and the collection of data be it personal data or even not personal data, is inextricably linked together. It's those tags executing, and that's what you're going to be able to manage when it comes to being compliant in this privacy context. So those are the two different EU regulations. Let's quickly touch on the California Consumer Privacy Act. There's a decent amount of information in these slides. I'm just going to kind of quickly go through it and touch on the main points. If you do have users accessing your websites in the United States, likely some of those users are going to be residents of the state of California, or if you're a global organization, you just have United States markets or sites in the US, for sure you're going to have California residents that are accessing those websites. As a result, you're going to need to adhere to this new act. So under this, there are 5 different rights that are granted to Californians with relation to their personal information. The first, the right of Californians to know what personal information is being collected about them. Very straightforward. The second one, the right to know whether personal information is sold or disclosed and to whom. Third, the right to say no to the sale of personal information. Fourth, the right to access personal information. And then 5, the right to equal service and price, even if they exercise their privacy rights. A lot of this is very much kind of in parallel with GDPR, but a little bit less stringent in many cases, as well as the requirements for who this applies to from an organizational standpoint is going to be a little bit more limited than those EU regulations that apply to everybody. So that's the first question. Who does this apply to? The CCPA applies to any business doing business in the state of California that meets any of the following criteria. One quick note on that, doing business in the state of California does not mean that you have to have a physical presence there. Does not mean that the the processing of the data, or your servers or anything are located in California. Simply means that you're doing business with a resident of the state of California, even if that resident is not within the state. So if you meet any one of the following 3 criteria, this law is going to apply to you. The first one is if your annual gross revenues are in excess of $25 million. If that's the case, boom, automatically CCPA applies to you. The second potential requirement is if you annually buy, receive for commercial purposes, sell, or share personal information of 50,000 or more consumers, households, or devices. That sharing thing is where most companies are going to fall under that requirement. If you're working with any like third parties, for example, and you're collecting personal information, which we'll get to the definition here in a moment, that's going to be sharing because you're the one that's collecting it. You're sharing with that third party in order to create audiences, run ads, whatever. The third requirement here is if you derive 50% or more of your annual revenue from the selling of consumers' personal information. A big key here is publishers. Publishers are just naturally, as long as it's an ad-based model, you're going to be selling your consumers' personal information because you are, identifying those users or even just characteristics about those users, and then you're selling those audiences, in order to make money. That's your entire revenue model. So most publishers are going to be caught in this as well. So as long as you meet one of those 3 criteria, the CCPA applies to you. And then businesses that meeting those criteria collect. Basically, if you collect or sell a consumer's personal information, it's going to be enforceable against you. Some important definitions here for the CCPA because it does vary and alter slightly from the traditional definition like PII, as well as the definition of personal data under GDPR, although it is very, very, very similar to that definition of personal data as defined in GDPR. So important definitions: collect, any buying, selling, gathering, obtaining, receiving, or accessing of personal information. It's going to be like collecting, as well as by observing the consumer's behavior. This is where it really relates to tag governance. By its very nature, even when we're we're just analyzing consumer behavior on a website. What pages are they going to? What products are they viewing? What are they adding to their cart? How are they interacting with our checkout process? What's being purchased? How am I assigning conversions? All of that. That's observing a consumer's behavior. There is an exception for counting ad like impressions or clicks, but anything beyond that super base level of collection or observation is going to fall under that collect definition. Selling, renting, releasing, disclosing, disseminating, make available, transferring, all that constitutes as selling of personal information. So again, transferring, that's huge. Again, if you're working with third parties, you're transferring audiences for advertising purposes between one platform to another. Selling that information basically, as long as there is some sort of valuable consideration or monetary gain from doing so. Personal information under the CCPA, this is key information that identifies, relates to, describes, is capable of being associated with, or could reasonably be linked directly or indirectly with a particular consumer or household. One thing that's explicitly noted in the law, this does include internet activity, including browsing, search history, as well as web tracking data. So again, tags, any tags or data collection that you're doing on the website, that's going to fall under that personal information because again, we are observing consumers' behavior. We're assigning unique identifiers pretty much uniformly across all platforms, and all that's covered here. Finally, a consumer, again, is any natural person that is a resident of California. It does apply to California residents outside of the state as well, similar to how GDPR would apply to any EU resident, including at points when they're outside of the EU. So what are the different categories of personal information? There's a lot of, when it comes to classification as well as disclosure, the biggest thing that we're needing to disclose to our users or our consumers is categories of personal information that are collected. As it relates to marketing and advertising technology, therefore the tags and tag governance on our websites, there's really four. There's a number of categories that are listed, I believe 12 in total. But these four are going to be what's collected and what's going to need to be disclosed. First one is like standard PII, so like real name, IP address, address, phone number, those sorts of things. The second one is any internet or electronic network activity information, browsing history, search history, information regarding a consumer's interactions with the websites, all that. So that's typically going to be that category of personal information that is collected as it relates to the different tags and marketing advertising technology on your site. Third one's geolocation data. And then the fourth is any inferences that are drawn from any of that personal information. So if you're doing any type of, again, audience creation or generalization about individuals based upon individual data points that are collected, that's going to fall under a separate category of personal information as well. So the requirements. First one, biggest thing is transparency and disclosure. Again, similar to pretty much uniformly across all countries under the EPrivacy, users need to be disclosed. Cookies are being used as well as they have the right to opt out. In this scenario, users need to be disclosed to or have visibility into personal information that's being collected about them, the fact that it is, to what platforms, how it's being used, and what categories of personal information are being collected and shared. So the first requirement for disclosure is at or before the point of collection. This is typically going to be done with a banner of some sort. First thing that needs to be disclosed is the categories of personal information to be collected. Second one is the purpose for which those categories of personal information shall be collected. Why are we collecting that information? How are we using it? Third, the notice of collection of any additional categories after that initial happens. So basically, if it's being processed in that last piece, if it is being combined or any generalizations or inferences are going to be made based upon that information. The fact that that's happening, as well as what the purpose is for it and what the result is. In addition to disclosure at the point of collection, you also need to disclose consumers' rights, description of the consumer's rights not to be discriminated against, so disclosure of transfers to third parties, as well as the right of erasure. All those things need to be additionally included within your privacy notice. The fourth piece here when it comes to transparency is disclosures must be in a form that is reasonably accessible to consumers and updated at least once every 12 months. So you need to be proactive with this. Got to know what personal information is being collected, by whom, what third parties is it being shared with, which is key, as well as what the result is or how it's being used. Some additional information there that's necessary for disclosures, as well as information requests. Similar to GDPR, users do have a right to request what personal information has been collected about them, as well as the specific pieces of personal information that's being collected. This is super important and why you need to have a great understanding of what platforms are loading on your website, what data is being collected, how it's being used, specific data points, all that. Under this law, you must be able to provide this information for the past 12 months of data collection and sale. The law goes into effect January 1, 2020. Enforcement goes into effect July 1, 2020. That means today, as we sit here, beginning of April, you've got about 3 months to really get all of this mapped out. Again, if you do fall under those different requirements for businesses operating in the US with respect to California residents, in order to be able to get this ironed out so that you would be able to provide the past 12 months of information to these users upon request, and to not have action be potentially taken against you. Some additional requirements here: erasure. Users have a right to have their information erased. Right to opt out must be very easy to do so. They must understand how to do so. And at that point, once someone opts out, you can no longer collect information about that user for 12 months, actually, until you can even ask to do so again. There's also a right to opt in for younger users on the website, just so the requirement to collect that information in the first place is a little bit more stringent. And there are some specifics that are outlined within the law for like what the button needs to say in order to allow people to opt out in cases in which you're selling personal information. Important part here, penalties. So it's not quite as, at first glance, initially scary, I guess, when compared to GDPR, but state action can be taken for up to $2,500 per violation if it's an unintentional violation, and up to $7,500 per violation if it's intentional. Now, for a large organization, a large website with a lot of users, a lot of traffic, even in the case of an unintentional violation, so say you have a third party that's piggybacking, loading through another tag that you have implemented on a website and collecting a unique cookie ID, personal information under the law. Say it's collected that information for 1,000 users. At that point, you're looking at up to 1,000 different unique individuals. That's 1,000 different violations. You'd be looking at a $2.5 million action in that scenario. Now, there are some exceptions. You do have 30 days following a judgment in order to be able to rectify the information, and you can get out of paying that particular fine, but that's going to be a mad scramble during that 30 days. It's much better to get all this in line and in place prior to that enforcement happening. And 1,000 users for many websites that are going to fall under that, if you're doing over $25 million worth of annual revenue, you're probably going to have a lot more than 1,000 users. So these fines can get massive. In addition, similar to GDPR, the right of individuals to file a private action is also there. So class action lawsuits, reputational damage, all that can compound the potential penalties that you would see for violations. So now that we have reviewed the requirements in the privacy environment today, What does this mean for your business? Number one, and where you need to start today, if you haven't done so, is you have to understand what are the tags and what are the platforms that are loading on your website. In many cases, and this is just a screenshot from one of our tag inspector audit reports, and so you can see there's a lot of piggybacking activity. You'll have third parties that are loading through or piggybacking off of other tags that are implemented on a website. In these cases, you're still responsible for the information that's being collected by those different third parties, even if you or your marketing teams or advertising teams aren't even aware initially that those platforms are loading information. If they're collecting personal data as defined by GDPR, if they're collecting personal information as defined by the CCPA, if they're setting cookies, and that activity is not documented, is not, regulated, and that users don't have the ability to opt out of all those things, you're in violation of those laws, and so you're open to those penalties. So number one, understand all the different platforms that are loading on your website. Once you go through that, and what it really means for you is understand the platforms that are loading first. For each of those different platforms, go through it in just a general tag governance type of exercise. Is this necessary? Do I need it? Are we using it? Is it a legacy tag? Is it something that can be removed? Once you understand all the things that should be there and you've removed things that shouldn't be there, that are unauthorized or just not necessary for your business, start asking yourself, for each of these platforms, what data is collected that needs to be mapped out for all of the different tags and platforms that are executing on your site? And then for each platform, is the data collected considered personal data under GDPR? Is it considered personal information under CCPA? Is it considered, personal or sensitive data under any other laws or regulations that might apply to your industry as well? If you are collecting personal data, so if you're saying yes to any of those different things, you need to start then walking through that process. For GDPR, what is my legal basis for processing? Are the appropriate measures in place protecting that information or that user? Am I following all the proper rules and requirements for consent? Do I have all the documentation necessary for legitimate interest? Those questions are going to depend upon which option you're using as that legal basis, but you need to be able to walk through and document and answer all those different questions. For the CCPA, you're going to need to start asking what categories, for the personal information that's being collected by these platforms, what categories do those fall under? For what purpose are we collecting this information? With whom is it shared? How are they using it? What is the effect on the user? And then are the proper disclosures, both at the point of collection as well as in my privacy notice, are all those things in place? And do my users have the ability to opt out? Is that available? Is that easy for them to do? Is the information that I'm collecting structured in such a way that I can easily erase it, as well as easily provide it to those individuals as well? Finally, beyond just the data that's collected when those tags are executing and by those platforms and what's being processed, we also need to think about what are the cookies that are being set by each platform in order to be able to make sure that we're compliant with our ePrivacy regulations. If cookies are being set, which 99% of the time, there is going to be some sort of a cookie that's set by the various different platforms or tags that are executing. We need to understand what are the conditions based upon the country in which that website is located or where those users are coming from. What are the requirements for placing that cookie, proper notifications made, ability to opt out there, and then are my tags configured in such a way that they can adhere to those different user preferences that would be defined. Quick visual for what this can look like. Step one, like I mentioned, just assigning ownership, understanding business purposes, understanding the different tags that are loading on your website. This is a format that I use, again, pulled from our Tag Inspector platform, that'll just list all the unique platforms, category, subcategory of each, and then some different questions and columns there that allow you to really walk through the process. Who's the business owner? Is there an agency partner responsible for these different things? Has it been approved by legal, been approved by security, been approved by performance? Is it something that I want to keep that's allowed to be on my website, or is it something that I want to move? And then is it loading in the proper way? Do I need to migrate it to my tag management system in order to be able to more easily manage? This is what you can use to provide the basis for a tag governance policy. And then once you have those allowed and required platforms, then we can start thinking about those different privacy laws and making sure that everything is adhering to them as it relates to compliant data collection. So similar process and similar formats, but going through those same questions and those same steps as it relates to each of the specific regulations. So for GDPR, is personal data collected? So what is my legal basis for processing that personal data? What is my consent mechanism? Do I have records of consent if I'm using consent? Do I have documentation if I'm using legitimate interest? All of that. For the CCPA, is personal information being collected? So what? What are the specifics that are being collected? What are the categories? Is it sold? Is it shared? Do I have the proper disclosures? Do my users have the ability to opt out of each of those different pieces? EPrivacy, we're looking at the cookies. Is consent, do I have the proper method of consent that's applied to the website or to each of those tags, dependent upon the different countries that I'm looking at? So again, high level at first, understand what tags are loading. Number two, understand is the information that's being collected and processed, is it applicable under any of these different laws or regulations? And then working through for each, is it compliant? How can we optimize this? So those are the requirements, what you need to understand, what you need to really factor into compliant data collection, your data collection and tag management architecture. How can we optimize? So number one, you're going to have consent considerations. In many of these cases, and what many organizations are beginning to say is that consent's easier. It's applicable and necessary across a few of these different laws. And it's much easier than trying to do a bunch of different privacy gymnastics in order to be able to collect this information. When we think about the consent process, though, how can we optimize it? How do we optimize user experience as it relates to consent? Because the more consenting users that we have, the more data we can collect and the more of a competitive advantage we're going to have over those other organizations that have a poor consent experience, aren't collecting that data, or collecting it in a non-compliant way. Second part to keep in mind and how to optimize is your tag management process and policy, making sure that compliant data collection is not something that is just happening at first when you do the audit, when you do the architecture, but making sure that you have the proper policies and processes in place, that new tags that are added, everything goes through with privacy in mind, and only compliant data collection happens on the site moving forward. A big part of that is essential ownership of tag management, not having a bunch of different hands in the cookie jar, if you will. So not allowing a lot of different parties or third parties or partners to implement tags, add tags on the different website. Own it, in-house or with a single partner, and be able to keep control over the architecture and the compliant data collection. Utilization of central data objects. We always recommend this just in general for analytics purposes and optimizing data collection, but using a data layer. Consolidating all of the different data points so you can really keep control of what is the information that is even available at the outset to be collected and used by the different third parties and the different tags that you're loading on your site. Fifth thing here, accountability, making sure and holding both contractually as well as operationally, holding your different partners and platforms that you're using and vendors that you're using accountable for compliant data collection. And then finally, ongoing monitoring, making sure that you have some processes in place to ensure that only compliant data collection and only authorized, approved tags and vendors are loading moving forward. This is a screenshot from our Tag Inspector platform of a policy. So once you define that governance policy, translating it into a platform such as Tag Inspector to be able to automate that that process of monitoring moving forward. Last thing I want to just touch on here is ITP considerations. So as a lot of people might be aware, Apple has begun rolling out ITP, which is the Intelligent Tracking Prevention Initiative, within Safari browsers on both mobile as well as desktop. So the version of this that's currently live, the intent was to put a stop to third-party cross-site tracking, so cookies basically that are being set and being able to be read by third parties across different domains. So tracking individual users across the web. In response to this, most advertising marketing technology put in some fixes, if you will, where they started setting cookies in a first-party context, so on the domain or from the domain of the website, but then aggregating information about each of those individual users on the back end to be able to, again, tie sessions and everything together and build a profile of those users. In response, Apple recently, at the end of February, announced that some additional restrictions. And now even first-party cookies, any cookie that's set via JavaScript running, so via any tags that are loading on your website, the expiry is going to be limited to 7 days. And third-party cookies are basically purged almost immediately after 24 hours. So what this means for your organization, basically cross-site tracking capabilities or third-party cooking and reading, which is the traditional model for a lot of advertising technology, is basically going away. So first thing you need to do is understand what is the different vendors you're working with, what is their response to ITP, how are they going to be managing this, how are they going to be handling it, and how should you potentially be changing your expectations of what's possible with the different technologies you're using. The limit to the first-party cookie expiry of 7 days is also going to potentially change how your reporting looks, even in things like analytics. Imagine if I'm a user and I come to your website today and then I return 2 weeks later to buy something. I'm going to show up as a new unique user in those 2 weeks because that cookie that's identifying me as a particular user is going to be expired by then. So it's going to make multi-touch attribution or attribution over time much more difficult. And it's also going to make some of the numbers potentially within just your base reporting a little bit wonky. In response to this, we need to start thinking about, what are some maybe changes to goals as well as measurement. So how are we doing that attribution? How can we encourage users to return to our websites, within that 7-day period? That way, that 7-day period is going to be extended each time that user visits our site. So how can we maintain that visibility, as well as potentially starting to emphasize things like logins or subscriptions? Because if you have a user ID that is associated with that user once they log in, that's obviously going to persist because it's going to be something that you have on the back end. So it's really raising the importance of things like subscription, sign-in, and starting to be able to prioritize those things on our website. So with that, I know it's a lot to digest, but basically in summary, privacy landscape is changing. It's no longer a best practice. It's now a requirement to have privacy in mind when it comes to our users and our customers on our websites. We need to be able to understand what platforms are loading, what data is collected, how it's used, where it's shared, and we need to be transparent. Well, it's required that we're transparent about all of those things, as well as giving our users the ability to opt out or consent to the collection and use of those different data points. Thank you all very much for joining. As mentioned before, we do have another webinar on Tuesday. We'll be going through a lot of the new UI updates, changes that have been made, and some of the new functionality that's available to users that are using Tag Inspector. So please join us for that. If nothing else, register, you'll get a recording. And yeah, if you have any questions at all or specific use cases around tag governance, or making sure that you are collecting data in a compliant manner and optimizing that data collection, optimizing and really enhancing your data collection and architecture, please don't hesitate, reach out. We're happy to help, happy to provide any guidance, and answer any questions that you might have. So Thank you all very much again for joining, and we hope to see you soon on future webinars. Thank you.